Supreme Court of Florida is now in session. All way across the plea. Draw near. Give attention. It shall be heard. God save these United States, great state of Florida, and this honorable court. Gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is in re amendments to Florida Rule of Civil Procedure 1.220.
Good morning, Your Honor. May it please the Court. My name is Scott Diamond. I'm here as Chair of the Civil Procedure Rules Committee. I'll let my co-counsel make their own appearances.
Kathleen McElroy on behalf of the Pro Bono Legal Services Committee.
Good morning, Your Honor. Good morning, Justices. Donnie McKenzie on behalf of the Pro Bono Standing Committee.
If it pleases the Court, Ms. McElroy and I are going to split our time for our initial presentation. I'm going to limit my remarks to discussing confirmation of the Court's authority to accept these revisions because they are, in effect, merely procedural in nature and they are not substantive. Ms. McElroy will discuss the question of designating specific recipients for side prayer awards within the language of the rule. And then both committees have reserved a short rebuttal period to address any remaining concerns that the Court may have. By way of brief background, the proposal that we're here to discuss today passed by civil rules by a relatively wide majority, 19-5. It was ultimately approved by the Board of Governors unanimously. It passed the Pro Bono Committee unanimously as well. So while there isn't a minority opinion with regard to the Court's authority to issue this rule, it is a relatively small minority. And it is primarily driven by the concern that the proposed rule is substantive rather than procedural in nature.
Counsel, let me ask you a question. If you were in the probate rules and the Probate Rules Committee had passed or had recommended a rule, and the Board of Governors had unanimously sent it on to us, recommending it, that for trusts where the original purpose is no longer able to be, say there was a school that the trust funded that is somehow closed, and it would allow the probate judge to, under cypress, allow for some sort of similar purpose, the money to be used for some sort of similar purpose. Would that be a substantive or procedural rule if the committee had passed that?
Well, I believe if there's already, in effect, if you have the same circumstances we have here, which is consent of the parties involved and no one losing the funds that are issued, then it would not be substantive any more than this rule is substantive.
How's that the case if the legislature has passed almost that identical statute here and it's one of the ones that's cited by the parties, 736-0413 sub 1.
The legislature passed a rule dictating what would happen in that circumstance?
Well, I don't know. They passed a rule. They passed a statute that authorized it. Was the legislature acting unconstitutionally when it passed that statute?
Well, I don't know the probate context specifically, but again, if there is a context in which everyone agrees to the donation, then you don't need the legislature enacted. It may be in that case because there's nobody agreeing to it from the other side. In effect, the folks whose will it was, they're dead. They can't change their mind. The legislature in that context may have to say, well, there is no consent to this. In fact, it's contrary to the decedent's consent. And therefore, in that context, it may be substantive. In our context, you're talking about a rule where everybody's agreed. The folks giving the money have agreed. The folks getting the money have agreed. The court has consented to it. And in that context, there's no one whose will is not taken into account. And furthermore, in that context,
there's certainly some people that haven't agreed, and even assuming that consent somehow affects the substantive procedural aspect of it, and I'd like for you to explain that for me a little bit more, but there's some people who are receiving money who have not been reached out to or have not claimed it, who have not consented, right?
Well, I disagree, Your Honor, respectfully. I think those people have consented because, understand, this money is by definition and by the language of the rule residual. It only occurs in circumstances where you've tried to give it away and then for whatever reason it can't be given away. So the folks who are ultimately supposed to get it are never going to get it. And I would submit that money that you cannot get is the same thing as money you do not have.
But why shouldn't it be something, why shouldn't it be, even if it's residual, something that the legislature should be the one that is responsible for determining what happens with the residual fund?
Because all the parties involved have agreed to it. It's no different than if anybody, if the plaintiffs agree to give it and the defendants agree to give it and the court approves it, whose rights are being trampled upon? At the end of the day, consent, if you read the minority position, their concern is somebody's money is being removed without their consent. And I reject both parts of that. Nobody's money is being removed because these are people who are never going to get this money by operation of the class action mechanism. And their consent is implicit because the class representatives have agreed on their behalf. And these are the same people who consented to the satisfaction of the claim in the first instance.
If the legislature had passed a law which said that all unclaimed funds in the court registry after a year is to achieve to the state and to be deposited with the Department of Financial Services, would that be a substantive or procedural law?
I think that would be substantive because the money is there and it would otherwise not be given away. That's what happens now.
Right.
It's 5 years now. If this money doesn't get given away, Your Honor, it goes to the state.
So how can we procedurally pass something that substantively the legislature has already determined where it's supposed to go?
Because the legislature only deals with this in the event that no one else has given it away. We're talking about a circumstance where all the parties have already agreed to give it away. The legislature doesn't get involved in that circumstance in any other aspect of the class action rule. And this is, again, a consistent circumstance where the defendant who's giving the money agrees to do this, not only agrees to give it to charity, but has to agree to which charity to give it to. And the plaintiffs or the class representatives who represent the class members who aren't there for purposes of all aspects of their claim, including having compromised it in the first instance, they agree as well. So if the defendant agrees and the plaintiff agrees and the court approves it, whose money is getting taken away? There's nothing for the legislature to deal with because the parties have already done it. Now, if the parties don't do it, we have a statute. The legislature says any unclaimed funds sitting around from any purpose are sheets to the state after 5 years. That is the only other alternative claimant here. But that is not somebody whose rights are being trampled because that only comes into effect if there are no other claimants. And this whole mechanism provides for these people to agree to do something that they all want to do. You know, it's a little like when you have a contract that says this contract can be amended by both parties agreeing in writing. Well, of course, any contract can be amended by both parties agreeing in writing, and that's what's happening here. All of the participants in the process have agreed. I've agreed to give it.
You're now beyond your initial time. I'll let you keep going a while, but you're using up time.
I apologize, Your Honor. I just wanted to address Justice Luck's questions. And I'll conclude. At the end of the day, there were two aspects to the minority position. Somebody's money is being taken away without their consent. And I posit that that's not true in either case. It's not their money because they haven't claimed it. They no longer can get it. They will never get it. That's why you have these distributions. And it's not without their consent because their duly appointed class representatives who are entitled to speak on their behalf have agreed. So no aspect of the minority's position is accurate. It's nobody's money, and in any event, everybody has agreed to give it away. Thank you, Your Honor.
Kathleen McElroy on behalf of the Pro Bono Legal Services Committee. May it please the Court. Pro Bono Legal Services Committee, which I co-chair with Judge Vance Salter, and I worked on this rule. And the proposed rule is an extension of the prior work of the Florida Access to Civil Justice Commission and the Florida Civil Rules Committee. The rule before the Court is a collective product of those two efforts. The committee's goal was to craft a rule that would increase access to justice and assist the courts in dealing with residual funds while not impairing the property rights of class members.
Ms. McElroy?
Yes, sir.
Maybe you could have a little bit of personal confusion about some of the issues, the way they're discussed. But first of all, it looks to me like, and I think we probably could all agree, that the first part of the proposed rule is clearly procedural. It talks simply about timing and how things are done. Prior to the entry of a judgment, this happens, a report's going to be done. That would be procedural, correct?
That's correct.
Okay, and then you get to the unless otherwise required by governing law, it shall be within the discretion of the court to approve the timing, method of distribution of residual funds, that kind of thing. Now, both sides seem to cite two treatises that suggest that that is the substantive law. In other words, that in these kind of cases, a judge just has discretion to deal with residual funds. Is that correct or not?
The doctrine of cypre appears to give the court discretion to do that.
So, and it seems like this procedure is followed in cases throughout Florida and the rest of the country already, because folks recognize that substantively this is something a judge has discretion to do with residual funds, correct?
That is correct.
Okay.
Both state and federal courts at present do provide for cypre awards in circumstances. The ABA in 2016 suggested rules like this to give the court and the parties comfort that it is appropriate to particularly use it for access.
Let me ask you specifically, is there any reported Florida decision in which the cypre doctrine has been applied in the disposition of residual class action funds?
Florida state courts
Yes.
in which cypre doctrine has been used?
Right.
I believe there are a number of them, and there certainly are in the federal system as well. I know of no cases where a court says cypre is inappropriate. There are a few cases around the country where courts have said this particular charity is not closely connected enough with the class for it to be an appropriate recipient. But I'm aware of no cases where the cypre doctrine has been stricken in Florida.
And then, so the confusing part to me is it says, unless otherwise required by governing law, which seems to recognize that that last part is dealing with substantive law, but what is that supposed to be referring to? I mean, is it just an out, meaning that this paragraph really doesn't mean anything, or is it, or are you talking about some other specific law that might apply in a specific type of class action that would direct a different outcome?
In the event there was a different substantive law, or if the order awarding the cypre award already dealt with particular residual. For instance, in some class action settlements, it says that the residual goes back to the defendant, and in that case, this rule should not be applied, and that's what we're suggesting. Or if, for instance, the award that the court originally entered otherwise gave the funds to a particular organization as part of the residual, that this later consent should not be applied in that circumstance. And to the extent there are any other provisions of the law that would prevent this from occurring, that it was not the intention of this rule to abrogate those particular statutes.
So if the last paragraph sort of just recognizes existing law, which would allow a judge to exercise the discretion discussed in that last section unless otherwise required by law, is it correct that really what this rule is trying to do is trying to sort of guide the discretion of a judge who's faced with a situation where they're going to decide what equity requires with respect to residual funds toward the Legal Services or Florida Bar Foundation?
To guide it, to suggest that that's appropriate, to give them comfort that it's not inappropriate to do that. And in fact, it's our belief that class actions always involve a group of class claimants who otherwise would not be able to individually have access to justice because of the nature or the size of their claim, and that collectively, through the class action process, they're able to get that. And by that very premise that class actions, residuals are appropriate to be given to legal aid to help generally access to justice.
So how is this rule changing the status quo?
We don't think it's necessarily changing the status quo, but it's giving comfort and authority that it's appropriate to do this. It's not mandating that any awards be given. In other states, their court rules, much like this rule, actually mandate a percentage of residuals go to legal aid organizations. We're not suggesting that. We're just suggesting that it's appropriate.
Can you address why it's appropriate for the proposed rule to include the Florida Bar Foundation?
We included the Florida Bar Foundation because the Florida Bar Foundation, we believe, is uniquely situated to provide help in this regard. One of the reasons they're listed is they don't provide direct legal services, but they're a statewide organization who provides grants to other organizations.
But there are many organizations that provide aid to indigent individuals, so why should this organization be selected?
In some class action circumstances, when there's been a challenge to the appropriateness of the individual entity, it's been because they didn't have the geographic bandwidth to do it. And we believe the Foundation is the only statewide organization that has the bandwidth to both provide funds to any of the legal aid organizations in Florida or to create specific grant programs to address the needs of the individual class claimants, whatever the particular circumstance of that class action is. And we believe that they were a good example of an organization. It doesn't mandate that the money goes to the Foundation, but that they were uniquely situated to provide both the geographic bandwidth to all the legal aid grantees in the state or to create specific projects if that particular case demanded it.
Now, you're also consuming rebuttal time here.
I am.
You know, when that red light
Okay.
goes on, that means you've gone beyond your initial time.
Unless there are any further questions, we believe that the rule does not abrogate the rights of the parties, and we believe that access to justice issues are in fact appropriate recipients of the Sudbury Awards. Thank you.
May it please the court. My name is Lisa Tellum. I'm going to do three things with our time. I understand, based on the agreement among the parties, I have 15 minutes straight. I had requested 5 minutes for rebuttal. However, I will respect the wishes of the proponent. I am here in favor of access to justice. I'm going to do three things. I'm going to introduce myself. I'm going to give a little context as to why I'm here, and then I'm going to talk to the rule and, of course, answer any questions that you have. I am a native Floridian of several generations. I am a member of the bar. I am currently retired. I have been inactive or retired for well over a decade. I have no plans to actively practice. So I am here in my capacity as a citizen, as a resident, as a taxpayer, and as a property owner, consistent with access to justice. Specifically, this rule has come to my attention because I found myself involved with the justice system. And until the most recent spate of activity, which some people call my solar farm, I had never been sued before. The only other time that I had been sued was by Bank of America during the crisis. And so
I'm going to ask you to please direct your comments to the
rules.
proposal before the court. We're here to consider a particular proposal.
Will do.
So if you will direct your comments to that
Will
would
do.
be good.
So I have now become engaged with the justice system. I never practiced litigation or appellate law. And it is in that context that I come to you. And as an individual who has some knowledge of the law, but is effectively a regular citizen, my orientation toward the rules in general is that there are too many, and they are too cumbersome.
Well, let me
and they are,
ask you
they are
this.
yes,
Do you
sir.
agree that substantive law generally would allow, unless otherwise required by law, a judge to exercise the discretion as set forth in that sentence in the proposed rule?
I believe in the Seventh Amendment, if that's your question. Yes, I do.
That's not my question.
That is your question, because cypre is a concept of equity, and under the Seventh Amendment of the United States Constitution, that must be determined by a court and cannot be abrogated any other way than by the judge. So I'm not here to argue as to whether it's the legislature or it's the court, because I do believe...
You would agree that generally a judge could exercise the discretion as described in the second part of the proposal?
Not only do I believe it, I believe that that is the role of a judge, is to find equity and to find justice, and that is definitely within the discretion, because the role of a court is to ensure our freedom and our liberty under the Constitution, which the legislature cannot do. So that is not my argument. My argument is the rule is primarily substantive. And a substantive rule does not belong in a rule of court. That is a matter for the case.
The first part's procedural, right? Prior to the entry of any judgment under this subdivision, the court shall determine the total amount payable to class members. The court shall set a date when the parties shall report to the court the total amount paid? I mean, it's all a timing sort of procedure thing. The first part would be procedural, right?
Administratively, if I would have less of an issue with the admin aspect of it. I don't think that most judges have practice preferences, and it's, again, based on the court and the parties and to find justice. So I am in favor of less restrictions on judges exercising their discretion with respect to these sorts of matters. However, as a technical matter, Your Honor, I would, be hard-pressed to say that that's not administrative. And if the court finds that it has an interest in mandating everybody does everything 3 days and there's no discretion, that's a separate issue. That's perhaps a separate constitutional issue, but it is administrative. The rest of the rule, however, is substantive. I don't think it's appropriate to guide in rules. That is for the common law. It is for the facts of the case. There was an error made, with all due respect to my colleague, Mr. Diamond. The rule, as I read it, does not only apply in situations where there's consent by all parties, because it also applies in the case of a trial. And a trial, by its nature, a trial judgment does not mean that there has been consent. Now, that's my reading. In fact, my reading of the rule is that it favors trial over settlement, which also puts individuals at a disadvantage, because most individuals, including myself, who was never a trial lawyer, are by their nature disadvantaged. So that's not access to justice.
Do you have any particular expertise in class actions in general?
I have been involved in settlements of major class actions.
Okay. As a participant, as a class member, or as an attorney?
As an executive.
As a representative?
As an executive. So I left the law many years ago, and in my capacity, my specialty was mergers and acquisitions. And when you do mergers and acquisitions, you often have to look at litigation. And in the context of looking at litigation, you settle the cases.
It's the minority report, and I don't remember if this was your position, took the position that this rule was inappropriate because the funds belonged to class members.
I disagree with that, and I disagree with that because, number one, it's not always consented, as Mr. Diamond indicated, because if it's a trial order that says it's either the defendants or the plaintiff group, who is in that group may or may not be consented. If you're deemed to be in the class, you may or not be consented. Whether it's the defendants or the plaintiffs, that's a matter for the case. I mean, we can all lean a certain way. I can admit my bias, but that doesn't make it correct. The other issue is that there is indeed, as the court has seized upon, a preference in the rule, if not a directive, for a particular organization. And with no disparagement to the Florida Bar Foundation, that is affiliated with the court. So it's highly inappropriate for the public to be directed as to where their funds need to go and why. That, again, is a matter for the case. As an individual, I believe there is a huge disconnect between what members of the bar believe is access to justice and what regular people, regular homeowners, regular asset owners, regular family members, just regular people with claims that find themselves needing to go get a fair, impartial decision to help them so that they're not shooting each other or whatever, get an answer, is very different from what lawyers think of as access to justice. Our justice system was set up, the U.S. Constitution provides for the establishment of justice. The Florida Constitution provides for access to justice. Now, I'm not going to get into a federalism debate this morning, but it would seem to me that the state courts are, in general, the window to justice for 90% of people. And that is a function of practicality, of being in their community, of the structure of it, that the judges are elected to help understand the community, and the cost. And the reality is that there are a lot of rules that are very discriminatory, and this is a predicate to that. I want to make myself clear that are not helping regular people, whether it's monetary, whether it's you've got to pay certain fees, or whether it's trying to understand the gobbledygook in the rules, as opposed to going in and expecting that the judge is going to treat them fairly and equally, whether they have a lawyer or not. Now, I'm not going to argue that having an excellent lawyer is not a great thing. It's a wonderful thing. However, it is not possible, and it is not practical. Not only because they don't exist, because there's some culture issues in the bar, because it's cost prohibitive, and because there's just certain kinds of cases where it just doesn't make sense. Or you outlive your lawyer, dies on you, or whatever happens. So my orientation is that we should be empowering individuals and not the bar, and not creating more rules, particularly where the discretion of the court, as Justice Lawson has pointed out, is already there. It's a common law issue. It's a matter for the case. And any preference...
What would your reaction be to a provision similar to the California Code of Civil Procedure, Section 384, that says that residual funds may be paid to a nonprofit organization or foundation that supports projects that will benefit the class or similarly situated persons, or that promote the law consistent with the objective and purposes of the underlying cause of action, or to nonprofit organizations proving civil legal services to the poor, or as otherwise provided by law?
My reaction is it's better, but it's still not correct.
What would be, I mean, that seems to be what the law is. So what would be wrong
What
with
the
that?
law is, we can argue about originalism and natural law and all kinds of things. What the law is changes.
I
We
don't
know
think
that.
would
We
be
know what the law
profitable.
is changes because we've seen that. What the Constitution means changes, no matter how conservative you are, and I can admit my bias to being fairly conservative, it changes. So I am violently opposed to more rules. And I'm violently opposed to anything which complicates for the average person, as I believe it was Your Honor, or it was Justice Muniz indicated, there's a carve-out in there that's a mile wide. So I'm a regular person, I come to court because I got an issue with my car or my contractor or my, ex-boyfriend or, my mother's best friend, whoever it is, and I got to read this rule and wonder, what is this? Why? Why don't I just come to court and be able to understand that the judge is there to be fair and impartial and deliver equity and deliver justice? It doesn't do any good. It makes it hard. It overcomplicates the situation, which is exactly what the bar does constantly. I don't know what the page count is on the rules now from 1967, but it's in the hundreds, I believe. And my request that I will go ahead and just put on the table is that somebody at the court, maybe it's the clerk who's in charge of the rules, needs to start looking through those rules because there's a lot of them that are unconstitutional. This is not the only one. And I don't know, there's a moment in time now, we have 3 new justices, but if we're serious about access to justice in the 3rd largest state in the United States of America, it's not working out there. It's too complicated. And, the line about you can't ask a clerk a question about a basic thing, people need to know what they need to do to move forward so that they're not constantly getting defaulted out of their lives or having their lives taken over by lawyers. Because I think it was Justice Brandeis, well-intentioned people who don't understand are the greatest threat to our liberty. And a lot of the lawyers just still don't understand how hard it is for regular people to come to court. And any directive to preference one organization, the Florida Bar Foundation, may be a rock star. They may be the best in the state right now. That doesn't mean that they're going to be the best in the state tomorrow. So baking it in is inappropriate. I rest my case.
Thank you.
Very briefly, Your Honor, this is a practical issue. I've been doing class actions for 25 years. At the end of a class action, despite everyone's best efforts and good intentions, sometimes there's money left over. So one or two things are going to happen. Everyone's going to agree.
I'm sorry to interrupt you.
Sir.
So when Justice Lawson read that provision where he talked about the residual funds going either to groups that advance the sort of the issues underlying the lawsuit or that promote the interests of the class members. And then there was the third category, which is legal services for the poor. That seems different than the first two in the sense that with the first two, there's kind of a clear nexus to the subject matter of the lawsuit or to the people in the class. This, to me, seems like more of kind of a substantive judgment that, it would be a good, socially desirable use of these funds to help access to legal services. I mean, why should that be baked into the rule?
Well, there is a very close connection, I think, as my co-counsel mentioned, between the concept of class actions and the concept of access to justice. So at the very top level of this, the concept here is to give guidance to a court of one of the possible permissible recipients of these funds is organizations that promote access to justice.
But it seems like in the first two inquiries, there's the first two categories, you have to sort of go through this kind of case-by-case thoughtful analysis to see what the connection between the specific lawsuit and the specific potential recipients. This is more just kind of saying, per se, any class action sort of by definition has this connection to legal services to the poor, which doesn't, to me, that doesn't seem to be the case necessarily.
Well, this is guidance as to one possible outcome, and it's one possible outcome because it does connect to the whole concept of the class action mechanism. But this doesn't preclude the parties from agreeing to something else.
But why should it be included in there at all?
Because the purpose of this rule, Your Honor, was to give guidance to parties, to make them aware of the cypre mechanism. This ultimately came down as a request from this court that we look at this as an access to justice issue. And ultimately, this rule was originally promulgated as mandatory, and that was rejected by the committee because you can't force people to do it.
But it's really different. I mean, cypre, it originated in trust law where, you were trying, you had a specific request and you were trying to find something as close as possible to that. I mean, when people bring class actions over whatever the subject area may be, they're not doing it out of a motivation to try to provide legal services to the poor. Whereas they might be, if it's some privacy-related thing, maybe there's a connection to a group that, that does that. But, I mean, this seems like a very different sort of substantive value judgment that's being made.
To be clear, Your Honor, no one involved in the class action wants to give a nickel away to anyone. This happens when you have money left over that will otherwise just a sheet to the state. And in terms of providing some guidance, because the idea was to provide guidance to help folks do this, one of the reasonable recipients was something that promotes access to justice like the class action mechanism itself does. This doesn't preclude anybody from saying, you know what, we like the investor rights clinic at the University of Miami because they deal with investor rights, and in a class action my firm recently settled, that's what we did with the money. It was a class action dealing with investments and securities, and at the end of the day, there was money left over because it was going to cost more to distribute it than we had left, and it was given as a cypre award at the University of Miami Investor Rights Clinic, which perfectly jibed with the purposes of the underlying process of fulfilling investor rights. But in the case where, more generally speaking, you're fulfilling the right of people who otherwise can't afford to litigate to gain access to the courts, there's nothing wrong with giving some guidance to the court to say, you know what, another thing that gives access to the courts are the Florida Bar Foundation. This is a mechanism for allowing money to be distributed that gives folks access to the courts, which at the end of the day was the purpose for us being requested to draft this rule in the first place. And I think it is perfectly reasonable to have that option, even though it doesn't preclude more specific designations.
I mean, and I don't know that this is relevant to the substantive or procedural thing, but I mean, it seems like the whole genesis of coming up with this proposal was to not so much to improve the rules in a technical sense, but to advance the substantive goal of getting more money for these groups, whatever the kind of the merits of what, I don't think anybody is contesting, the merits of what those groups do, but it seems like the whole motivation for this rule was to get more money for these groups.
Well, the motivation of the rules to give guidance to circumstances that already exist where people are already permitted to do this. They may just not know it. And one of the reasons that the rule is requested is that there are judges and litigants who aren't familiar with the cypre mechanism. This will make them familiar with the mechanism that exists in the law today. And if all these folks got together and agreed to this and the judge approved it, they could have done this yesterday without this rule. And the idea is to provide some guidance that connects.
You really think that there's a lot of class action counsel that aren't familiar with cypre?
Absolutely. Absolutely. everyone's had their first class action, and I know a lot more after my 10th one than my first one, and there are judges I've been in front of who've never dealt with one before. I had my first state court class action, the judge was new to it, and that happens.
Why do we need a rule? Why not write just a law review article or do a seminar presentation?
Well, folks read rules more frequently, I think, than they do our law review articles, and ultimately the goal here
I think
was...
they'll read your law review article, Mr. Diamond.
If I ever write one, Your Honor, I'd be impressed if you read it. At the end of the day, the purpose of this
Mr.
was...
Diamond, you're way over your time
Thank
here.
you, Your Honor. I'm sorry.
Is there any time permitted?
Well, I'll give you some time, but I mean, we're kind of...
I don't want to speak just for the purpose of speaking, but to answer your question, Justice Muniz, the purpose of the rule, you stated earlier status quo. The status quo is that there is ignorance throughout the state of Florida, and the Rule 1.220, when it was created for access to justice. It was created to provide an avenue for people who could not otherwise afford to litigate on their own, an opportunity and a vehicle to litigate issues and to help the administration of justice in courts by allowing a large number of claims to be settled in a singular vehicle.
Is there any, as far as the status quo though goes, is there any appellate decision in Florida that has approved the idea that rather than choosing a recipient of funding that's connected to the actual lawsuit, that just per se legal services organizations are appropriate?
There are two 11th Circuit opinions. I've been unable to find a state court case, but there are two 11th Circuit cases, and there is a Southern District of Florida case that outlines and reiterates that courts have discretion to direct funds in a meaningful way that is arguably connected to the class action itself.
Right, but I'm asking specifically about legal services being per se appropriate, which is what this rule basically says. I mean,
well, I'm not sure about your meaning of the word per se, but I can tell you
what I'm saying is that you don't have to, if this rule were enacted, there would be no need to look at the sort of specific underlying substance of the lawsuit or of the class. You could just say, if it had, if it's a class action and there are residual funds, regardless of the subject matter of the case or the nature of the class, you would be able, it would not be an abuse of discretion for the court to choose a legal services group for the funding.
I think as the rule is written, you could imply that, but it's understood that there has to be some connection, and there's two connections to legal aid throughout the cases throughout the country. The first connection is that the rule itself is a mechanism to provide access to justice. Legal aid recipients there's 21 states who have adopted either a statute or the rules. And what we did was we tried to pick the statute or the rule that was least offensive and the most discretionary and permissive. But the purpose, the second reason why legal aid is recognized around the country and bar foundations are recognized as the appropriate recipients is because, for instance, you have a class action for consumer protection laws. Legal aid lawyers have consumer protection units. It is appropriate to say this class was a victim of a consumer protection scheme or scam or however you want to say it. There is no more person appropriate, no more organization appropriate than a particular legal aid organization that has a consumer protection unit. This is a class action involving housing authority or housing rights or name the issue. Legal aid organizations have dedicated departments throughout that address the particular issues that most class actions will address. And that's why legal aid organizations have been identified around the country as being the appropriate recipients. Bar foundations are recognized as the appropriate because the only case that I have found that has disqualified a Cypre award, Ninth Circuit out of California, it's because the judge made a Cypre award to a local legal aid organization, and there was favoritism or implied favoritism, and there was not a geographic reach. If you have a bar foundation...
Right, but how is that not implied favoritism here? I mean, this is a rule that is crafted, and then it specifically includes the Florida Bar Foundation, how is that not implicit favoritism in this case?
Because the reason why the bar foundations are put in these rules throughout the country are the bar foundations typically cover the entire state. So that if you have
I
a class
understand that
action-
they cover the entire state, but this is an inclusion of a specifically named organization, right? As opposed to saying you can award the thing directed to anything that has a nexus or connection to the underlying litigation, correct?
Understood.
And that's my concern, is that you're actually naming, the only organization that's being named here is the Florida Bar Foundation, where the Florida Bar is the person who is, the bar organization is the one that's suggesting this rule.
Understand that. And again, when we drafted this rule, we were using other states' languages that use that. And as I've written down, the two words in this rule, we could always write this rule better. And I understand the court has the option to do that. I would respectfully change both includings. I would change the first word, and this directly relates to what Ms. Tellem was talking about in her initial comment. The first including, I think, should say which may include, not including. And the second including, I think, should say and or. And that to me, I think, takes away the implication of a direction towards a particular organization. And there's nothing in this rule that prohibits a judge. In fact, the law states that, and the practical reality is there are residual funds in every class action lawsuit. A judge has got to do something about those funds. And the law is the judge has to tie it back to the cause of action if they can. And typically, in most instances, the judge will say, this was a housing authority case. This is a good case for legal aid housing authority lawyers. And honestly, I'm here on behalf of the Pro Bono Standing Committee, but I also happen to be the executive director of the Florida Bar Foundation. And I say this with all due humility. If you need to take out the Florida Bar Foundation in this rule, please do so. Because the greater good is to keep this rule in as guidance for courts to know that this is a vehicle that will help legal aid receive valuable funding from Cypre Award residual settlements. So if that has to happen, you have the Florida Bar permission, the Florida Bar Foundation's consent, acquiescence, permission, whatever it is, to take us out. But the reason it was put in is statewide geographic reach. Thank you very much for your time, Your Honor.
Thank you.
Thank you.
All right, we thank you all. Now move to the second case on our docket.